Welcome to this educational quizzer designed to enhance your understanding of the 2019 amendments to the 1989 revised rules on evidence. This is part 1 of 15 quizzer covering Rule 128 General Provisions and Rule 129 What Need Not Be Proved. By engaging with this quiz, learners will develop a deeper comprehension of key legal concepts in evidence, including the definition, admissibility, and relevancy of evidence, as well as judicial notice and admissions. This knowledge is critical for law students, legal practitioners, and anyone interested in the fundamentals of legal proceedings. Let's test and reinforce your knowledge of these amendments. Q1. What is the definition of evidence according to the 2019 amendments to the 1989 revised rules on evidence? Evidence is defined as the means sanctioned by these rules for ascertaining the truth regarding a matter of fact in a judicial proceeding. Section 1, Rule 128, Q2. Are the rules of evidence consistent across all courts and trials? Yes, the rules of evidence shall be the same in all courts and in all trials and hearings, unless otherwise provided by law or the rules. Section 2, Rule 128. Q3. Under what conditions is evidence considered admissible? Evidence is admissible if it is relevant to the issue and not excluded by the Constitution, the law, or the rules of evidence. Section 3, Rule 128. Q4. What determines the relevancy of evidence in legal proceedings? Evidence is relevant if it has a relation to the fact in issue as to induce belief in its existence or non-existence. Section 4, Rule 128. Q5. When is evidence on collateral matters allowed in court? Evidence on collateral matters is allowed when it tends in any reasonable degree to establish the probability or improbability of the fact in issue. Section 4, Rule 128. Q6. What are some examples of matters that courts must take judicial notice of without evidence? Courts must take judicial notice of the existence and territorial extent of states, political history, forms of government, and official acts of the Philippine government, among other things. Section 1, Rule 129. Q7. Under what circumstances may a court take judicial notice of matters on its own discretion? A court may take judicial notice of matters which are of public knowledge or are capable of unquestionable demonstration. Section 2, Rule 129. Q8. When is a hearing necessary for taking judicial notice of a matter? A hearing is necessary during the pre-trial, trial, before judgment, or on appeal if the matter is decisive of a material issue in the case. Section 3, Rule 129. Q9. Are judicial admissions in legal proceedings required to be proved? No, judicial admissions do not require proof and can only be contradicted by showing that they were made through palpable mistake or were not actually made. Section 4, Rule 129. This quizzer on the 2019 amendments to the 1989 revised rules on evidence has focused on key aspects of evidence, including its definition, admissibility, and relevancy. Additionally, it highlighted the concept of judicial notice and the use of judicial admissions in legal proceedings. By understanding these sections, learners gain insights into the procedural elements that affect the handling of evidence in Philippine courts, as prescribed by the amendments to the Rules of Evidence. These sections ensure consistency and fairness in legal proceedings by standardizing how evidence is treated and recognized, thereby safeguarding the judicial process and ensuring more efficient and just outcomes.